No doubt you clicked this video because you're chasing a debt, and even though the debt is not being disputed, the debtor is ignoring you or giving you the runaround. This is a huge red flag. Under Section 123 of the Insolvency Act, a company could be viable. It could have 50 grand in assets, it could have some money in the bank, it could even have a lucrative contract that it's working on. But if it can't afford to pay its debts as and when they fall due, this company is insolvent. In cases like yours, there may be grounds to petition for the winding up of the debtor company. Now, don't get me wrong, while this process often results in the debtor paying the debt to prove its solvency, this is not about debt recovery in the traditional sense. It's about addressing the underlying issues of insolvency. The reason why it's so important to keep this in mind is because if it's found that you have abused the process, then you can be subject to an adverse cost order, which essentially means you've lost the opportunity to have the debtor pay your costs, and you are going to also have to pay the debtor's costs. So remember, filing a winding up petition should be done in good faith, based on the belief that the company is insolvent and that the debt is genuinely undisputed. For creditors who are owed money, understanding the legal framework is crucial. This is a very nuanced area, and so it's so important to get things right. That's why you should always seek professional advice before you take any action. From my experience, I know that emotions are involved, and dealing with undisputed debts can be like banging your head against a brick wall. But it's very important to handle this situation intelligently and within the bounds of the law. So make sure to seek advice from professionals who have your best interest in mind. Try and do this as early as possible, and do all you can to avoid making mistakes along the way.